come from the tunnel.
College sports are big business, and more than a few of those dollars comes from licensing video games. But it may not surprise you that players don't see any of that money. That could be changing. Former Bruin Ed O'Bannon is one of several ex-college athletes now suing the NCAA on antitrust claims. Currently, even former college athletes cannot license their likeness because the NCAA requires they forgo these rights in perpetuity. The right to publicity is of specific interest to those involved in intellectual property law. The Legal Blitz sat down with Temple IP professor David Post to discuss this lawsuit. The first question we asked him, why is the right to publicity an issue of intellectual property?
It's not entirely clear that it is, in a sense. I mean, this is a nice case to illustrate a number of things about the law, including the fact that in the world, the law does not come in nice boxes. When you start approaching questions from the injured party's standpoint, look at these players, so former college, there's a whole bunch of plaintiffs in this action, but among them are several former college football players. And they come to their lawyer and they say, I've been harmed, something bad has happened to me. And the lawyer says, well, what is it? He says, well, they've used my likeness, my picture is there in that EA Sports video game. And I never gave them permission, and nobody ever asked me about that. And either they say, I don't like it, I don't want to be associated with EA Sports for some reason, or maybe I have a competing game, or I don't like EA games, or I don't like video games at all, or think it's evil and poisoning the minds of our children, who knows. Or they say, I really don't care, but I think I should be entitled to compensation for that. They're making money off of my likeness, I want a little bit of it. Whatever it is, the lawyer's job is then to go back and say, okay, is to think in terms of causes of action. One place you'd look is what is generally called intellectual property. And what is generally called intellectual property is are causes of action based upon the three main federal statutes. Lanham Act for trademarks, Patent Act for patents, Copyright Act for copyrights. That's traditionally considered sort of the core of what we call intellectual property. If you look in there, you're not going to find too much that's going to help Mr. O'Bannon, the ex-player. It's not going to help your client. Might have a trademark cause of action. I think they've included a trademark cause of action because the Lanham Act says anybody who's using a mark that suggests a commercial affiliation that is not present may be liable in certain circumstances. So one of the things I think that the players can say is that you're implying that we're sponsoring this, that we have a connection to EA Sports, and we don't have a connection to EA Sports. But their real cause of action, I mean, the guts of this case, is actually outside of what would traditionally be called intellectual property. They're bringing these what are effectively state tort claims. Right of publicity, primarily, some of which are common law. There's a common law right, at least for, quote, celebrities, people whose names or likeness have commercial value. There's a common law cause of action that enables them to stop uses of their likeness. Can't put Michael Jordan's picture on your billboard selling hot dogs and just say, hey, Michael Jordan's a good guy, come buy these hot dogs. He can control the use of his likeness. Under the common law of publicity, several states have their own statutes. Indiana has a statute, and California has a statute that gives you a publicity-type right of action. If your likeness has commercial value, no person may use it for commercial purposes without your permission. So to get back to your question, is that intellectual property is sort of a funny question in a way. It's a really interesting question in many ways. Most people would probably say, well, not really. It's not an intellectual property claim, among other things, for two reasons. One, it's not in this existing box. The existing box really has copyrights, patents, and trademarks. And it's not really what they're not suing under those statutes. They have other cause of action. The other reason you might say it's not intellectual property is that it is, in fact, a tort. And torts and property are very different from one another. It has smells like intellectual property in a way. It's closer to intellectual property than it is to real property. It concerns some sort of intangible interest in your own face. It's the sort of thing copyright law could protect but doesn't. And ordinarily, when we think of intangible rights, rights and intangible things, we think of intellectual property. But the line is really a very funny one. I don't consider this, at its heart, an IP case, although it clearly is of interest to people like me who are interested in IP. It's on the borders, it's on the boundaries of things that we would call intellectual property.
How close does the video game player have to look like the real player for there to be a misappropriation?
If a reasonable consumer would recognize that this is a real player, that this is based on Ed O'Bannon, whoever it is, as opposed to just a made-up cartoon video game person, that's probably the line. There will then be fighting about who's the reasonable consumer. I mean, if you think this is just the way the law works, right? Suppose that's the rule. The rule is if the reasonable consumer would recognize this as when say, oh, that's the guy who was quarterback at Ohio State in my game, woohoo, great. If that's the rule, then the parties are then going to spend a great deal of time fighting about who's a reasonable consumer. You can imagine the plaintiffs are going to say, oh, the reasonable consumer is some real football-savvy 19-year-old who spends all of his time, probably a male, watching football games on Saturday. Those are the guys you're really marketing to. The other side is going to say, no, I want, the random person picked on the street. Might be a woman, might be older. That's a reasonable person. We should take a much more. There's going to be fighting about the scope of the market, in effect. And how the court resolves that often determines whether or not there's a claim.
Does everyone have a right to their likeness, or is a certain level of notoriety required?
Under the standard common law publicity right, you have to have notoriety, as you put it. You have to have, again, the standards are a little bit nebulous, but most people don't have it. I mean, the point of the tort, in a sense, is to give special protection to people whose likenesses have clear commercial value. Michael Jackson, Elvis, etc. There are 50 states. Could they have a different definition in their statutory right of publicity? Absolutely. They could say everybody's got one, that no one may use anybody's likeness for commercial value without permission. So, and maybe there is such a thing. I mean, and I think the plaintiffs, I think they've chosen Indiana law to proceed on because they think Indiana law is particularly helpful to them. It's the broadest, gives them the broadest scope of the availability of these rights. But my basic answer to that question is the general contours of this tort was designed not for the average person, but for people whose likenesses are clearly of substantial commercial value.
Isn't there a friction between these laws and the First Amendment?
There is a First Amendment pushback on these laws. There sort of has to be. And by First Amendment pushback, I mean whatever these rights of state law are, there has to be an opportunity for a defendant, for example, to say this, abridges the freedom of speech in a manner that, at least say applied to me, is unconstitutional. It has to be most of these statutes, again, I was just doing a little bit of research in preparation for this, to sort of the Indiana statute in California. Most of them have either express or judge-made carve-outs. They'll have specifically in the statute, they'll say, except, you can't stop someone if it's news reporting, for example. If they're on the news, Tiger Woods' very valuable likeness, but he can't stop the news channels from showing his face when they are reporting about Tiger Woods. And we wouldn't want a right of publicity, I think, obviously, to do that. And the First Amendment would not permit it. So if you had one of these statutes, sort of a naked right of publicity statute, and Tiger Woods went into Fox News and says, I want an injunction again. You put me on the news last night. It's very embarrassing about my whatever. I want you to take that off. They would be able to say, well, maybe you have this right under the statute, but the First Amendment trumps a statutory right, and we have a right protected by the First Amendment to go ahead with this. Most of these statutes already say that, or the judges interpreting them have already said that. So there's always a tension between granting very broad rights, protection rights, on the one hand, and the First Amendment values on the other. They're going to come into conflict. Most of the statutes and the common law sort of recognize that and allow you to raise, at least in your defense, the notion that if the statute is interpreted to cover this, the freedom of speech has been impinged. EA Sports might, in this case, the First Amendment problem is often solved doctrinally because we're only talking about commercial uses. And the Supreme Court in the First Amendment area has said, commercial speech kind of gets less protection. If you just, look, if the state of Indiana is giving the celebrity, Bono, the right to prevent his likeness from being used in commercial advertising, and if the commercial advertisers come in here and say, oh, First Amendment, they're probably not going to succeed because it's commercial speech. And the Supreme Court has said, we're not that concerned. I think they're wrong about that, but they have said we're not that concerned about commercial speech problems. But most of the statutes sweep much more broadly than that, and the broader it gets, the more likely it is that you will run into an objection that says this is impinging on people's ability to show photographs of people who are in the news. And to the extent that's true, that has very deep First Amendment implications and will be part of the analysis of this case, for sure.